Before we begin, it's crucial to understand that this video is for informational purposes only and is not legal advice. The information provided in this presentation does not create an attorney-client relationship. You should consult with a qualified professional for advice regarding your individual situation. The legal landscape is complex and varies by state, and the choice of a lawyer is an important decision that should not be based solely upon advertisements or this video. Let me tell you about Sarah. Sarah had what everyone, including the police, called a slam-dunk personal injury case. A commercial truck ran a red light and T-boned her car. The police report was crystal clear. The truck driver was 100% at fault. Sarah was injured, her car was totaled, and her life was turned upside down. Feeling overwhelmed, she did what most of us would do. She turned on the TV, saw a lawyer with a catchy jingle and a tough guy persona on a massive billboard and thought, "That's the one. He's the best." He had 5-star reviews, a flashy website, and promised to fight for her. She signed the papers, relieved to have a so-called heavy hitter in her corner. Fast forward 9 months. Her slam dunk case was settled for a fraction of its actual worth. The settlement barely covered her initial medical bills, leaving nothing for her future surgeries, lost wages, or the chronic pain she would now have to manage for the rest of her life. What went wrong? Sarah didn't hire a bad lawyer. She hired the wrong lawyer. And that single mistake, that one decision made under stress and based on marketing, cost her dearly. The paralyzing question isn't just, how do I find a lawyer? It's, how do I find the right lawyer for me? And the answer is almost never on a billboard, in a slick TV ad, or on a generic top 10 lawyers list that's really just a paid advertisement. The entire concept of the best lawyer is a myth. It's a marketing trap. There is no single best lawyer in your city, any more than there is a single best doctor. If you had a complex heart condition, you wouldn't go to the best doctor who happens to be a podiatrist, would you? Of course not. You'd find the best cardiothoracic surgeon with a proven track record in your specific procedure. Yet, when it comes to law, we throw that logic out the window. We get intimidated by the complexity, we're swayed by aggressive marketing, and we end up choosing a generalist for a specialist job. We ask our real estate agent for a divorce lawyer recommendation. We hire the guy who handled our uncle's DUI to draft a multi-million-dollar business contract. This is the single most critical error people make, and it's an error that law firms with massive advertising budgets count on you making. This video is going to change that, for good. Over the next few minutes, we are going to give you a foolproof step-by-step system for finding the exact right lawyer for your specific, unique situation. We're going to demystify the entire process. We will teach you how to see past the marketing fluff, how to vet a lawyer's actual experience, and how to identify the critical red flags that should have you running for the door. By the end of this guide, you won't just feel more confident. You will be equipped with the insider knowledge to select an attorney who gives you the absolute best possible chance of success. This is your guide to what best lawyer really means. So let's start with the biggest lie in the legal industry: the illusion created by advertising. Law is a business, and in the United States, it's a very competitive business. Lawyers, just like plumbers and car companies, need clients to survive. The ones you see most often on TV, on billboards, on the radio, are often the ones who are the best at marketing, not necessarily the best at law. Think about it. A massive advertising budget doesn't pay for legal expertise. It pays for airtime and ad space. These firms, often called settlement mills, operate on a high-volume, low-touch model. Their goal is to sign up as many cases as possible, as quickly as possible, and settle them as quickly as possible, often for less than their full value. It's a numbers game. They might handle thousands of cases a year. Your slam dunk case, like Sarah's, becomes just another file in a very, very tall stack. The lawyer you saw on TV? You'll probably never speak to him. You'll be handed off to a junior associate or a paralegal, who is juggling dozens, if not hundreds, of other cases just like yours. Their incentive is to close your file and move to the next one. They get paid by settling, not necessarily by getting you the maximum possible compensation. They're looking for the quick, easy win, not the best win for you. This isn't to say that all lawyers who advertise are bad. That's not true at all. But it is to say that advertising is not, and should never be, a measure of a lawyer's skill, dedication, or suitability for your case. A lawyer's true value isn't found in their marketing budget. It's found in their experience, their reputation among other lawyers, their trial record, and their specific expertise in your area of need. The truly elite specialists, the lawyer you actually want for a complex medical malpractice suit. A high-stakes business litigation, or a contentious custody battle, often don't need to advertise. Their reputation precedes them. They get their clients from referrals from other lawyers, from judges, from former clients who were so impressed with their work that they become walking, talking advertisements themselves. These are the lawyers whose names get passed around in quiet, confident whispers, not shouted from a billboard. So, your first mental shift has to be this: stop looking for the most visible lawyer. Start looking for the most respected one. This means you have to become a detective. You have to ignore the shiny objects and the catchy jingles and start digging for the substance underneath. The first step in this detective work is to completely reframe your search. You are not looking for a lawyer. You are looking for a very specific type of expert. Before you even type a single word into a search engine, you need to define your problem with as much precision as possible. Don't just say, "I need a business lawyer." What kind of business issue is it? Are you forming an LLC? Are you negotiating a commercial lease? Are you dealing with a trademark infringement? Are you raising venture capital? These are all wildly different specialties. The world's best trademark lawyer might be completely lost when it comes to securities law. The same goes for personal injury. "I was in a car accident" is a starting point, but we need to get more specific. Was it a motorcycle accident? A trucking accident? Did it involve a drunk driver? Was there a product defect in the car that contributed to your injuries? Trucking litigation, for example, is a universe unto itself, with complex federal regulations that a general car accident lawyer may know nothing about. Hiring the wrong specialist is like bringing a knife to a gunfight. You're outmatched before you even begin. So, right now, take a moment and define your legal problem in one precise sentence. I need a family law attorney who specializes in high-asset divorce cases involving business valuation. Or, I need a personal injury lawyer with a proven track record of taking cases against commercial trucking companies to trial and winning. Or, I need a criminal defense attorney who focuses specifically on federal white-collar crime. This level of specificity is your new search query. It's your compass. It immediately eliminates 95% of the lawyers in your area and allows you to focus only on the small pool of true specialists who are qualified to handle your case. It transforms your search from a random, hopeful shot in the dark into a targeted strategic mission. This single act of defining your need is the most powerful first step you can take. It's the foundation upon which your entire successful outcome will be built. Once you have this sentence, you are no longer a passive consumer of legal advertising. You are an educated buyer in control of the process. And from this position of power, we can begin to find the right person for the job. So where do you start? Your first instinct might be to look up to that billboard on the highway with the lawyer in a power suit, pointing a finger, promising justice. Or maybe it's that commercial that plays during the late-night news, with a catchy jingle and an easy-to-remember phone number. It's tempting, it's easy, and it's almost always the wrong place to start. Let's pull back the curtain on the legal marketing machine for a moment. That billboard, that TV spot, that full-page ad in the phone book, what does it actually tell you about a lawyer's ability? It tells you they have a massive marketing budget. That's it. It tells you nothing about their success rate, their courtroom demeanor, their communication skills, or their reputation among judges and other attorneys. In fact, in some legal circles, a heavy advertising presence can be seen as a sign of a high-volume, low-touch practice. The kind of place where your case becomes a number on a spreadsheet processed through a system designed for efficiency, not necessarily for your specific, unique, ideal outcome. They are casting the widest net possible, hoping to catch as many clients as they can. You, with your carefully crafted sentence, are not looking for the widest net. You are looking for a spear. Then there are the online lists. Super lawyers. Best lawyers in America. Top 100 trial attorneys. They have impressive names and professional-looking badges you'll see plastered all over attorney websites. Some of these accolades are legitimate and based on peer review, but many of them are simply pay-to-play. A law firm pays a fee, they get a plaque for their wall and a digital badge for their website. It's a marketing tool, not a merit-based award. It's designed to make you feel confident, but it's often built on a foundation of sand. Relying on these lists alone is like choosing a surgeon based on who has the shiniest plaque in their waiting room. It's a terrible metric for a decision this important. So, if we ignore the billboards and take the online awards with a massive grain of salt, where do we turn? We turn from broadcasting to narrowcasting. We stop looking for the most visible lawyer and start looking for the most respected one. And we do this by building our search on 3 foundational pillars. The first, and by far the most powerful pillar, is the personal referral. I'm not talking about your cousin's brother-in-law who does law. I'm talking about a strategic, targeted request for a recommendation from someone you trust who has faced a similar situation. The power of a personal referral isn't just in getting a name, it's in getting a story. You can ask questions you can't ask a website. How did they make you feel? When you were terrified and called them at 8 p.m. on a Friday, what happened? Did they explain things in a way you could understand? Were there any surprise fees? If you had to do it all over again, would you hire them? A referral from a trusted source gives you a priceless behind-the-scenes look at the client experience. But don't just ask friends and family. Expand your thinking. Ask other professionals you trust. Your accountant, for example. They work with business lawyers, estate planning attorneys, and tax specialists all the time. They know who is meticulous and who is sloppy. Your family doctor. They often have professional relationships with the best personal injury and medical malpractice attorneys in your city. Your real estate agent knows the top real estate lawyers. These professionals have a vested interest in recommending good people, because their own reputation is on the line. They are a curated, pre-vetted source of high-quality referrals. The second pillar, if a personal referral isn't an option, is the bar association. Not just any Google search, but a direct inquiry to your official state or local bar association. Every lawyer who practices in your state must be a member of the state bar. It's the official licensing and regulatory body. Most of them have a lawyer referral service, and it's a vastly underutilized resource. This isn't the yellow pages. To be listed on these referral services, especially for a specific practice area, lawyers often have to meet certain criteria. They have to prove they have a certain number of years of experience in that field, carry malpractice insurance, and be in good standing with the bar, meaning no recent disciplinary actions. Going a step further, look for specialty bar associations. These are national or state-level organizations dedicated to a single area of law. Planning a divorce? Look at the American Academy of Matrimonial Lawyers. Facing a criminal charge? The National Association of Criminal Defense Lawyers. These aren't clubs you just pay to join. They often have rigorous vetting processes, requiring peer recommendations, extensive experience, and sometimes even a separate exam. Finding a lawyer who is a member of one of these elite, specialized groups is a massive green flag. It tells you they are not just a lawyer. They are a lawyer's lawyer, recognized by their peers as a leader in their field. Now for the third pillar. This is the one most people never even think to use. I call it the reverse engineering method. Instead of asking who advertises the most, you start asking, who do the other lawyers and judges respect? Who would the other side be afraid to see you walk in with? This takes a little more work, but the payoff is immense. How do you do it? Start by reading. Look up local legal publications or even the business section of your local newspaper. When a major, complex case is in the news, who are the lawyers being quoted? Who is representing the big companies or high-profile individuals? These are often the attorneys who have built a reputation for handling the toughest, highest-stakes work. Here's an even more inside baseball trick. If you ever have a reason to be at the courthouse, watch and listen. Court clerks, bailiffs, and judicial assistants see lawyers in action every single day. They see who shows up prepared and who is fumbling through their notes. They see who is respected by the judge and who is barely tolerated. While they might not be able to give you a direct recommendation, paying attention to the courthouse ecosystem can reveal who the real players are. You can also look at who is teaching the law. Check the websites for local law schools and see who is teaching as an adjunct professor. The lawyers who teach night classes on trial advocacy, contract negotiation, or family law are often the ones who are so respected in their field that they are asked to train the next generation of attorneys. They aren't just practicing law, they are defining it. Using these three pillars, the personal referral, the bar association, and the reverse engineering method, you are no longer just looking for a lawyer. You are hunting for the right lawyer. Your goal at this stage is not to find the one. It is to assemble a shortlist, a dossier of 3 to 5 highly qualified, well-respected candidates who appear to have the specific expertise your problem requires. This process transforms you. You move from being a passive consumer, susceptible to slick advertising, to an active investigator, a discerning buyer gathering intelligence. You're not just looking at a website, you're looking at a reputation. You're not just reading a slogan, you're analyzing a career. Now you have a list of names. Not just any names, but names backed by reputation, specialization, and trust. But a name is just the beginning. In the next step, we're going to turn this list into a conversation. We're going to prepare for the single most important meeting you'll have, the initial consultation. And I'm going to give you the exact questions to ask to uncover the truth about whether they can deliver the outcome you wrote down just a little while ago. This meeting is not a sales pitch. Let me say that again. The initial consultation is not a sales pitch where you sit there politely while a lawyer in a fancy suit tells you how great they are. That's the frame they want. That's the frame that puts them in control. We're going to shatter that frame. From this moment on, you need to think of the initial consultation as an audition. You are the director of a multi-million-dollar movie. The movie of your life, your business, your future. And the lawyer walking into that room is an actor auditioning for the most important role in the entire production. They are there to prove to you why they deserve the part. You hold all the power. You ask the questions. You decide if they get a call back. When you shift your mindset from, I hope they'll take my case, to, I will see if they are worthy of my case, everything changes. But a great director never walks onto set unprepared. Your preparation for this audition begins now. First, you're going to create what I call the case Bible. Get a simple 3-ring binder. In it, you will assemble every single piece of paper, every email, every contract, every text message screenshot, every photo, every document that is even remotely related to your situation. Don't edit, don't second guess, just gather. Then, arrange it all in chronological order. The goal here is not just to be organized. It's to create a physical, tangible narrative of your story. When you can hand a lawyer a well-organized binder, you immediately signal that you are serious, competent, and not a time waster. Commands respect before you even say a word. Second, write on the inside cover of that binder, I want you to place that single sheet of paper we talked about, the one with your desired outcome written on it. The one that says, success for me looks like. This is your North Star. Every question you ask, every answer you hear will be measured against that statement. Third, you're going to write a one-page summary, a statement of facts. Use bullet points. Start with the date the issue began and walk through the key events, dates, and people involved right up to the present day. Make 5 copies of this page. When you sit down in the consultation, the very first thing you do, after shaking their hand, is hand them this one-page summary. This is a power move. Instead of you nervously rambling for 20 minutes while they try to figure out what's going on, you've just handed them the entire story in a format they can digest in 90 seconds. You have taken control of the narrative. You have framed the conversation. Now, while they're reading that, you open your notebook to a clean page, and you get ready to run the audition. The questions you're about to ask are divided into 3 acts. Act 1 is about their past, the resume. Act 2 is about the present, the strategy. And Act 3 is about the future, the relationship. Let's begin with Act 1, the resume. You cannot be shy here. Vague questions get vague answers. You need surgical precision. The first question is not, have you handled cases like this before? The answer to that will always be yes. The real question is, in the past 36 months, how many cases have you personally handled that involved? And here you insert the core issue of your case. A specific type of contract dispute, a particular kind of injury, a niche area of family law. You need a number, a specific number. If they hesitate or say, oh, a lot, you press gently. Could you give me a ballpark? Are we talking 5 or 50? An expert knows their numbers. Once you have that number, you follow up immediately. Of those cases, what was the typical range of outcomes? And can you share 1 or 2 non-confidential examples of a successful strategy you used that you were particularly proud of? Listen carefully to this answer. Are they talking about their actions or just vague results? A great lawyer will say, we had a similar case where the opposition filed a motion to dismiss. We countered with a specific legal precedent from a 2018 case, which completely changed the leverage and forced a favorable settlement. A bad lawyer will say, yeah, we got a great result for the client, they were very happy. See the difference? One is a detailed strategy, the other is a fluffy sales pitch. The final question in Act 1 is critical to avoid the old bait and switch. Who specifically at this firm will be doing the day-to-day work on my case? And who will be my primary point of contact? In many large firms, the senior partner with a great reputation meets you for the consultation. But once you sign the check, your case is handed off to a junior associate you've never met. You have a right to know who you will be in the trenches with. If they say it's an associate, you ask, can I meet them for 5 minutes before I leave today? Their reaction to this question tells you everything about their firm's transparency. Now we move to Act 2, the strategy. This is where you find out if they are just a legal historian or a brilliant tactician. The first question here is designed to test their honesty and their analytical skill. Based on the summary I gave you and what I've told you so far, what do you see as the top 2 or 3 strengths of my case? And more importantly, what are the top 2 or 3 weaknesses? If a lawyer only tells you how great your case is, you should stand up and walk out of the room. They are either lying to you or they're incompetent. A true expert, a true strategist, is obsessed with risk. They see the potential landmines before they ever take a step. They should be able to articulate your weaknesses even more clearly than your strengths. That's the person you want on your side. The one who is already planning for the worst-case scenario. Next, you test their vision. Putting aside the legal jargon for a moment, if you were to explain the strategic game plan for my case to me like I'm a smart friend, what would it be? Are we playing offense, aiming for a quick, decisive victory? Or are we playing a long game of defense, designed to wear down the opposition? What is the path from here to the desired outcome I wrote down? You're looking for a clear, logical narrative. Does their plan make sense? Does it feel like it connects to the outcome you want? If their strategy is to drag things out in court for 3 years but your goal is a fast, quiet settlement, you have a fundamental misalignment. Finally, we arrive at Act 3, the relationship. This is where most people fail. They get so caught up in the legal brilliance, they forget they're about to enter into one of the most intense and stressful professional relationships of their life. First, the communication question. What is your firm's communication policy? How often can I expect to receive proactive updates from you, even if there's no news? And if I have an urgent question, what's the best way to reach you? And what is your typical response time? Get specific. Proactive updates are key. You don't want a lawyer you have to chase for information. Second, the money. Never ever be afraid to talk about money. Can you provide me with a complete and detailed breakdown of your fee structure? What is the retainer? What is the hourly rate for you for an associate for a paralegal? And what are the other costs I should anticipate, things like filing fees, expert witness fees, court reporters? I want to understand the total potential financial scope. A good lawyer will welcome this question and provide a clear, transparent fee agreement. A lawyer who gets defensive or vague about money is a massive red flag. And now for the last question. It's the most important one you will ask. It's simple, it's direct, and it's the one question they will probably never have been asked before. After you've discussed everything else, you look them in the eye and you ask, "Why do you want to take my case?" And then you stay completely silent. Let the silence hang in the air. Their answer will tell you everything. Are they giving you a canned response about loving justice or helping people? Or do they say something that shows they were actually listening? Do they say, "Because the way your former business partner structured that exit clause is something I find intellectually fascinating and I see a clear path to victory"? Or, "Because I listened to your story, and I believe a fundamental injustice was done here, and that's the kind of fight I'm passionate about"? You're listening for a spark, a genuine connection to your specific problem. You are not just a file number. You are not just a paycheck. You are a cause they are willing to champion. After the audition is over, you thank them for their time. And no matter how great they seemed, you do not hire them on the spot. You never ever make a decision in that room. You simply say, "Thank you, this has been very informative. I'm speaking with a couple of other attorneys and I'll be in touch within the next week." You've completed the auditions. You've gathered your intelligence. Now comes the most critical part of the process, the final decision. Because the lawyer's performance inside the consultation room is only half the story. The other half is revealed in what they do after you walk out the door. And there are subtle, almost invisible red flags in their follow-up that 99% of people miss. In the next part, we're going to decode those signals and make the final definitive choice. The first signal arrives within 48 hours. It's a test, and most lawyers don't even know they're being graded. After you've met with 3 or 4 potential attorneys, you go home, your head spinning with legal jargon and possibilities. You wait. And how they break that silence tells you almost everything you need to know about the months, or even years you might spend with them. The first type of follow-up is no follow-up at all. This is the ghoster. In the meeting, they were charismatic, confident, and promised you the world. They shook your hand firmly, looked you in the eye and said, "We'll be in touch." And then crickets. A week goes by. Nothing. This isn't just bad manners. It's a preview of your future. If they aren't hungry enough to secure your business when you're a hot new lead, imagine how they'll treat you 6 months from now when you're just another file in a cabinet, calling to ask for an update. Their silence is screaming that your case is not a priority. Cross them off the list. The second type is the polar opposite and far more dangerous. This is the pressure cooker. Their follow-up is immediate, aggressive, and relentless. You get a call the next morning, then an email, then another call from their intake specialist. They create a false sense of urgency, telling you that the clock is ticking, and you need to act now before it's too late. They'll dangle a discounted retainer fee if you sign within 24 hours. This isn't the behavior of a confident professional. It's the tactic of a high-pressure salesperson. They're not selling you a legal strategy, they're selling you a product, and that product is them. They want to get your signature on a retainer agreement before you have time to think, before you can talk to another firm, before you can read the fine print. This approach is a colossal red flag. It signals a firm that prioritizes volume and revenue over client well-being and careful, considered legal work. Run, don't walk. Then there's the delegator. You get a prompt, polite email a day after your meeting, but it's not from the lawyer you met with. It's from a paralegal or a junior associate. The email says something like, "Mr. Smith asked me to follow up with you." Now, this isn't automatically a bad thing. Good law firms are teams. But the key is how the handoff happens. If the partner you met with never personally communicates with you again, it suggests a bait and switch. They brought out the senior partner to close the deal, but you'll be working exclusively with less experienced staff. The best firms handle this gracefully. The partner will send a personal email first, summarizing your conversation and then introducing the team member who will be your day-to-day contact, saying something like, "I've personally briefed Sarah on your case, and she will be your primary point of contact, but I will be overseeing every step of the strategy." See the difference? One is a dismissive handoff. The other is a structured, team-based introduction. Finally, there's the professional. Their follow-up is the gold standard. It arrives within 1 to 2 business days. It's a personal email from the lawyer you met. It thanks you for your time. It briefly and clearly summarizes the main points of your discussion and the potential strategy they outlined. It doesn't pressure you. Instead, it provides value. It might say, "As we discussed, the next step would be X. I've attached our standard retainer agreement for your review. Please take your time to look it over, and let me know if you have any questions. I'm here to help." This response is confident, respectful, and client-focused. It demonstrates organization, good communication, and a belief in their own value. They don't need to pressure you because they know they're the right choice. This is almost always your lawyer. But even with the perfect follow-up email in your inbox, the final decision comes down to one of the most misunderstood documents in the legal world: the retainer agreement. People are so relieved to have found a lawyer that they just sign it. This is like buying a house without reading the contract. It's a catastrophic mistake. This document isn't a formality. It is the entire rulebook for your relationship. You need to read every single word, and there are 3 specific sections you must scrutinize. First, the scope of representation. This section defines exactly what the lawyer is agreeing to do for their fee. Vague language here is a trap. Does it say they will handle your personal injury claim? That's not good enough. Does that include filing a lawsuit? Does it include taking depositions? Does it include representing you at trial? Or does it just cover writing a few demand letters and trying to negotiate a quick, cheap settlement? Many a client has been shocked to learn that their flat fee only covered the pre-litigation phase, and that going to court will cost them tens of thousands more. The scope should be spelled out in painstaking detail. If it's not, demand a revision. Second, the fees and expenses. Don't just look at the percentage or the hourly rate. Look at the expenses. The contract will state that you are responsible for all case-related expenses, but what does that include? Expert witness fees? Court filing fees? The cost of photocopies and postage? Some unscrupulous firms turn the expense sheet into a profit center, charging you 50 cents a page for copies that cost them 2 cents, or billing you for administrative fees that are just part of their overhead. The agreement should be clear. For contingency fees, it's crucial to know if the attorney's percentage is calculated before or after expenses are deducted from the settlement. This one detail can change your take-home amount by thousands of dollars. Let's imagine a $100,000 settlement. The case had $10,000 in expenses. If the lawyer's 33% fee is calculated before expenses, they take $33,000. Then the $10,000 in expenses is deducted. You're left with $57,000. But if the fee is calculated after expenses, it's different. The $10,000 in expenses comes off the top, leaving $90,000. The lawyer's 33% of that is about $30,000. You're left with $60,000. It's a $3,000 difference hidden in one sentence. Third, and most overlooked, is the termination clause. This section explains what happens if you want to fire your lawyer or if they want to drop your case. If you fire them, how is their fee calculated? Do they get their full contingency percentage even if you do most of the work with a new lawyer? Or do they get a reasonable hourly rate for the work they actually performed? This is a massive point of contention. And what if they want to fire you? The agreement should specify the conditions under which they can withdraw. If it gives them a vague, unilateral right to drop your case for any reason, that's a red flag. You don't want your lawyer to abandon you halfway through a fight because a bigger, more profitable case walked in the door. After you've compared the follow-up, after you've dissected the retainer agreements, there's one final test. It's the one that logic can't solve. It's the gut check. You're about to enter into a relationship that requires absolute trust, often during the most vulnerable time of your life. So ask yourself, how did this person make me feel? Did I feel like a human being with a problem they genuinely wanted to solve? Or did I feel like a number on a spreadsheet? Did they listen more than they talked? Did they explain complex ideas in a way I could understand? Or did they use jargon to make themselves seem smarter? Did they seem to care about justice or just about the fee? This isn't about finding a new best friend. It's about respect and confidence. You must have unshakable confidence that the person sitting across from you has your back, that their primary motivation is your best interest. If you have even a flicker of doubt, if there's a little voice in the back of your head saying, something's not right here, listen to it. No matter how impressive their credentials are, no matter how great their office looks, if your intuition is screaming no, you have to walk away. Because that small flicker of doubt can grow into a wildfire of regret down the road. You've done the work. You've sifted, analyzed, and listened to your gut. You make the call, you sign the agreement, and you hand over the retainer check. A wave of relief washes over you. The burden is finally off your shoulders. You've hired the best. But this is a dangerous moment of peace. Because the single biggest mistake a client can make happens in the first 30 days after hiring their lawyer. It's a subtle error in communication and expectation setting that can poison the relationship and cripple a case before it even gets off the ground. And in the next part, we're going to make sure you don't make it. This single mistake is the #1 reason promising lawyer-client relationships turn toxic. It's not about incompetence or malpractice. It's about the devastating power of silence. We call it the expectation gap. And it opens up the moment you sign the retainer agreement. Let's imagine a guy named Mark. Mark was in a nasty rear-end collision. He did his research, found a personal injury lawyer with stellar reviews, had a great consultation, and hired her on the spot. He felt a huge wave of relief. Finally, someone was in his corner. He signed the papers, shook her hand, and went home, confident that the wheels of justice were now turning. And then nothing. A week goes by. He hears nothing. He tells himself, she's busy. Top lawyers are busy. That's a good sign. 2 weeks go by. Still crickets. The anxiety starts to creep in. He sends a polite email. Hi, just checking in to see if there are any updates on my case. A day later, he gets a one-line response from a paralegal. We are in the process of gathering your medical records. We will be in touch. A month goes by. Now Mark is starting to panic. The relief he felt has evaporated, replaced by a gnawing dread. His inner monologue turns dark. What if I'm just another case file on a massive pile? Did they forget about me? Are they even working on my case? Or did they just take my money and move on? He starts rereading those 5-star reviews, wondering if they were all fake. The trust he had in his lawyer is not just gone. It's been replaced by active suspicion. The relationship is poisoned. Now let's pull back the curtain and see what was actually happening at the law firm during that silent month. Was the lawyer on vacation in the Bahamas? Was she ignoring Mark's case? Not at all. The moment Mark left the office, she and her team kicked into high gear. They were in what's called the investigation and evidence preservation phase. It's one of the most critical parts of any case, and it's also the quietest. In that first week, they sent a spoliation letter to the trucking company that hit Mark, legally demanding they preserve the truck's black box data, the driver's logs, and all maintenance records before they could be accidentally destroyed. They subpoenaed the complete 911 call recordings and the full unredacted police report. They contacted and took recorded statements from the 2 witnesses listed on the report before their memories could fade. In the second and third week, while they waited for those items to come in, they sent formal medical record requests with Mark's authorization to his primary care physician, the hospital emergency room, the orthopedic specialist, and the physical therapy clinic. Anyone who's ever dealt with medical administration knows this isn't like ordering a pizza. It's a slow bureaucratic process that can take weeks, even months of follow-up calls and paperwork. During that silent month, Mark's legal team was fighting a dozen tiny battles on his behalf. They were building the foundation of his entire case, brick by painstaking brick. So why didn't they just tell him all this? From the lawyer's perspective, she was protecting her client. She thought, why would I bother Mark with daily updates about administrative tasks? He's trying to recover from his injuries. He hired me to handle the stress. I'll call him when something important happens, when we have all the records, when we get a response from the insurance company, when we have an actual significant development to discuss. Do you see the disconnect? Mark's expectation was, I need to know you're working for me. I need to feel like a priority. The lawyer's assumption was, my client wants results, not a running commentary. No news is good news. Neither of them was wrong, but their uncommunicated expectations created a chasm of misunderstanding that destroyed the trust essential for a successful partnership. Every phone call from that point on would be tinged with Mark's suspicion and the lawyer's frustration. This is the trap you need to avoid. And you avoid it by establishing what we call a communication covenant before you sign anything. This isn't about being a needy or difficult client. This is about being a smart professional partner in your own legal case. You must get clear, unambiguous answers to 5 specific questions during your initial consultation. Write these down. Question number 1. What is your firm's primary method of communication? Is it email? Phone calls? Do they use a secure online client portal? You need to know where to look for information and how to send it. If you hate email and they run their entire firm through it, you're setting yourself up for frustration. Question number 2. Who will be my day-to-day point of contact? In many firms, you'll speak mostly with a dedicated paralegal or case manager. This is perfectly normal and often more efficient. But you need to know that up front. If you expect to speak with a senior partner every time you call, but their system routes you to a case manager named Susan, you're going to feel ignored and passed off, even if Susan is a brilliant professional who knows your case inside and out. Get the name and title of your primary contact. Question number 3, and this is a big one. What is your firm's policy on response times? Ask it directly. If I leave a voicemail or send an email, what is a reasonable time frame to expect a response? A good firm will have a clear policy. 24 business hours, 48 business hours. The answer itself is less important than the fact that they have an answer. It shows they have a system and respect their client's time. If they get vague and say, oh, we get back to people as soon as we can, that's a red flag. It means they have no system. Question number 4 is the secret weapon that would have saved Mark all his anxiety. In a case like mine, what are the typical quiet periods? And what specific work is being done behind the scenes during that time? This question forces the lawyer to walk you through the case timeline from their perspective. They'll say, okay, for the first 30 to 60 days, we'll be in the investigation phase. You likely won't hear much from us, but here's what we'll be doing. Subpoenaing records, contacting witnesses, etc. Then once we have everything, we'll move into the demand phase, and you'll be much more involved. Just hearing this completely reframes the silence. It's no longer a sign of neglect. It's a sign that the plan is working. And finally, question number 5. Can we establish a regular schedule for updates?
Propose something simple.
Would it be possible to get a brief email update on the 1st of every month, even if it's just to say, we're still waiting on records from the hospital? This creates a predictable, automatic touchpoint. It's a safety net for your peace of mind. A confident, client-focused firm will have no problem with this. They'll likely already have a system like this in place. Imagine if Mark had asked these 5 questions. He would have known that the first month would be quiet. He would have known his point of contact was a paralegal. He would have known not to expect a response for 24 hours. And he would have received a simple scheduled email on day 30 that said, Hi Mark, as planned, here is your monthly update. We have successfully obtained the police report and witness statements. We are still awaiting medical records from the orthopedic specialist. We will continue to follow up, and will let you know when they arrive. The case is proceeding as expected. Same situation, same lawyer, same amount of work being done. But for Mark, the experience is transformed from one of anxiety and suspicion to one of confidence and trust. He feels respected, informed, and in control. The best lawyer for you isn't just the one with the best legal mind. It's the one who runs the best professional operation. They understand that their job isn't just to manage your case, but to manage your peace of mind along the way. Your job in that first meeting is to find out if they have the systems in place to do it. Now, once you've navigated the communication minefield and found a lawyer you trust, you're faced with the single most confusing and intimidating document in the entire process: the fee agreement. This is where the real horror stories begin. Most people hear contingency fee and think it means, I pay nothing unless I win. That is a dangerously simplistic and often incorrect assumption. The hidden expenses, the administrative fees, the costs you are on the hook for even if you lose your case. These are the details buried in the fine print that can leave you with a massive bill and nothing to show for it. And in the next part, we are going to dissect the modern fee agreement and expose the 3 critical red flags that you absolutely must look for before you ever sign your name. Alright, let's break this down. The fee agreement. Most people see it as a formality, a piece of paper you have to sign to get to the real work. That is a catastrophic mistake. The fee agreement isn't the prelude to the battle. It is the first battle. It's where the terms of your surrender or your victory are written, often in dense, impenetrable legalese designed to be skimmed, not studied. This document, more than any other, reveals the true character of the law firm you're about to hire. It tells you whether they see you as a partner in a difficult journey, or simply as an account to be drained. And right now, we're going to give you the X-ray vision to see through the boilerplate and spot the ticking time bombs hidden inside. The first and most common red flag is what I call the phantom scope. It's the art of using vague language to promise you the world while committing to almost nothing. Let me tell you about Maria. She was an incredibly talented chef who wanted to open her own small restaurant. She found a lawyer who seemed great, and he said he'd handle her business setup for a flat fee of $5,000. Maria was thrilled. She thought, great, he's handling everything. She signed the agreement, paid the fee, and a few weeks later, she received a folder in the mail with her LLC formation documents. That was it. When she called her lawyer to ask about the commercial lease for the restaurant space, he said, "Oh, the lease review. That's not part of the business setup. That's a separate matter. My rate is $450 an hour." Maria was stunned. What about my permits? My employment contracts? The lawyer's answer was the same. Separate matters. Not included. Maria had paid $5,000 for something she probably could have done herself online for a few hundred. The lawyer wasn't technically lying. He did set up her business, but he used the vague term business setup to create an expectation he had no intention of meeting. He defined the scope in his own mind in the narrowest way possible, while allowing her to believe it was all-inclusive. This is a classic trap, so here's how you avoid it. You never, ever accept a vague description of services. You demand an itemized statement of work, just like you would from a building contractor. This statement must explicitly list, in plain English, every single task the lawyer will perform for the agreed-upon fee. And just as importantly, it should have a section for what is excluded. Will it include filing the initial documents? Yes. Will it include drafting the company's operating agreement? Yes. Will it include negotiating your commercial lease? No. Will it include handling litigation if you get sued? No. Getting this level of clarity isn't being difficult, it's being a smart client. If a lawyer resists providing this level of detail, that is your signal to run, not walk, to the nearest exit. They want to keep it vague for a reason, and that reason will always cost you money. The second red flag is far more insidious. It's a financial trap called the evergreen retainer. Now, most people know what a retainer is. You pay the lawyer a lump sum up front, say $10,000, and they bill their time against that money. When the money runs out, you pay more. Simple enough. But the evergreen retainer has a nasty twist. Buried in the agreement will be a clause that says something like this. Client agrees to maintain a minimum balance of $3,000 in their retainer account at all times. Should the balance fall below this amount, client authorizes the firm to automatically charge client's credit card on file to replenish the retainer to its original full amount of $10,000. Think about what that really means. Let's take the case of David, who was fighting for custody of his kids. He paid a $20,000 retainer. His lawyer was billing aggressively, and after a month, the balance dipped to $19,000. David thought he still had plenty of runway, but the evergreen clause had a $5,000 minimum. So the firm automatically charged his credit card another $5,000 to bring the balance back up to $20,000. Suddenly, a surprise $5,000 charge hits his account. He calls the firm confused. They explain the clause. Now David is in a constant state of anxiety. Every email, every phone call isn't just a part of his case. It's a potential trigger for another massive, automatic credit card charge. He feels a complete loss of control. The law firm has no incentive to be efficient. They have your credit card number and a license to charge it whenever they see fit. They are always working with a full pot of your money, and you're just scrambling to keep up. It's financial quicksand. Here's the counter move. You read the retainer section with a magnifying glass. If you see the words evergreen, replenish, automatic, or minimum balance, you stop. You cross it out. You tell the lawyer you are not comfortable with an automatic payment system. Propose a different arrangement. Tell them you will pay the initial retainer, and you will pay their monthly invoices within 30 days to keep a positive balance. Or, at the very least, you can amend the clause to state that any replenishment of the retainer requires your explicit written authorization for each transaction. This puts you back in the driver's seat. It forces the lawyer to justify their work and their fees to you before they get more of your money. It restores the proper balance of power. Now for the third and most audacious red flag of all. This is the one that shows a stunning level of arrogance from a law firm. It's the unilateral fee modification clause. It sounds boring, but it's a dagger aimed at your wallet. It's a sentence, usually buried deep in the agreement, that says something like, the firm's hourly rates are subject to change at any time. The firm will provide client with 30 days written notice of any such change. Let me paint you a picture. A small software company gets sued by a massive competitor. It's a bet the company lawsuit. They hire a sharp, aggressive lawyer for $600 an hour. It's expensive, but they can manage it. They're a year into the case. They've spent hundreds of thousands of dollars. They're heading into the most critical phase. Depositions and expert witnesses. Then they get a polite letter in the mail. Dear client, please be advised that as of next month, my hourly rate will be increasing to $900 an hour. A 50% increase overnight. What can they do? They are trapped. They are a year into the case. Firing the lawyer now would be suicidal. A new lawyer would have to spend months and hundreds of thousands of dollars just to get up to speed on the case. The first law firm knows this. They are exploiting their leverage. They waited until the client was too deep in to get out, and then they changed the rules. It's a strategic, calculated move to extract more money from a captive client. This clause is a non-starter. It is the ultimate sign of a one-sided relationship. When you find this clause and you need to look for it, you must demand that it be removed. You tell the lawyer that you need a rate that is locked in for the entire duration of your legal matter. If they are a big firm that has a policy of annual increases, you can negotiate a compromise. Insist that the rates quoted in the agreement are fixed for a minimum of 12, or better yet, 24 months. If they refuse to budge at all, if they insist on the right to change their fees whenever they want, you have to ask yourself a hard question. Do you really want to be in a long-term partnership with someone who demands the power to change the price on you at any time for any reason? The answer is no. A good lawyer, one who wants a partnership, will be willing to commit to a price. A lawyer who refuses is telling you right from the start that their financial interests will always come before yours. Looking for these three red flags, the phantom scope, the evergreen retainer, and the unilateral fee change, transforms you from a passive customer into an active, empowered client. It forces a conversation about fairness, transparency, and expectations before a single dollar is spent. An agreement without these red flags is the foundation of a healthy attorney-client relationship. But even with the most perfect, client-friendly contract in the world, you can still end up in a world of trouble. Because the contract governs the money, but it doesn't govern the human element. The most critical skills your lawyer will ever use on your behalf aren't about legal clauses or case law. They are the invisible skills, the ones that determine whether a judge trusts them, a jury likes them, or an opposing counsel fears them. And these skills are never listed on their website or in their fee agreement. In the next part, we are going to show you how to spot these game-changing qualities in your very first meeting. Your first meeting with a potential lawyer isn't just a consultation. It's an audition, and you are the director. You're casting the most important role in the story of your case, and your future depends on making the right choice. This meeting is where the slick website and the 5-star reviews meet reality. It's your one chance to look past the sales pitch and see the real person you'll be trusting with your money, your time, and your peace of mind. So how do you do it? How do you separate the performers from the true professionals? It starts with something most people get completely wrong. They go into that first meeting ready to talk. But your first job is to listen. Or more accurately, your first job is to watch how they listen. The very first test a lawyer must pass is the listening test. When you walk into that office and start telling your story, the one that's been keeping you up at night, the one you've replayed in your head 1,000 times, what do? Does the lawyer lean forward, make eye contact, and let you speak uninterrupted until you've said everything you need to say? Do they take notes, not just on the facts but on the emotions and the details that matter to you? Or do they cut you off after 30 seconds? Do they finish your sentences for you? Do they immediately start talking about a similar case they won, turning your story into a springboard for their own ego? A lawyer who can't give you 5 minutes of undivided attention when they're trying to win your business is a lawyer who will never give you the attention you deserve when they already have it. Great lawyers are information sponges. They know the most critical clues to winning your case are buried in your story. They listen patiently because they are hunting for leverage, for inconsistencies in the other side's potential story, and for the core truth of your situation. A bad lawyer just waits for their turn to talk. A great lawyer listens to understand, because they know that's the only way to truly win. Once you've told your story and they've passed the listening test, the next phase of the audition begins, the translation test. Law is a foreign language. It's filled with Latin phrases and convoluted terms designed to be impenetrable to outsiders. A mediocre lawyer will use this language as a weapon. They'll throw around terms like promissory estoppel, tortious interference, or motion in limine to make themselves sound smart and to make you feel dependent on their great knowledge. It's a power play, and it's a massive red flag. The best lawyers, the true masters of their craft, are expert translators. They have the rare ability to take the most complex legal concepts and explain them in simple, clear, everyday language. They don't need to use jargon to prove their intelligence. Their clarity is the proof. So, when they start explaining your situation, pay close attention. Do you understand what they're saying? Do they use analogies and real-world examples to make their points land? A bad lawyer might say, "We'll need to overcome the affirmative defense of laches." A great lawyer will say, their main argument will be that we waited too long to file the lawsuit. They're going to tell the judge that it's unfair to make them defend this now, after so much time has passed. Our job is to show the judge that we had a very good reason for the delay, and that they haven't been harmed by it at all. See the difference? One is confusing and intimidating. The other is empowering, brings you onto the team. It makes you a collaborator in your own case. If you walk out of a consultation more confused than when you walked in, that lawyer has failed the translation test. Run, don't walk to the next name on your list. Now for the most important part of the meeting. This is where you take control of the audition and ask the 2 questions that will reveal everything you need to know about their competence and their character. After they've listened to you and given you their initial thoughts, you need to look them in the eye and ask question number 1. Based on what you know so far, what is our game plan? What are the first 3 steps we would take if I hired you today? The answer to this question separates the strategists from the paper pushers. A vague, hesitant, or generic answer is a terrible sign. If they say something like, "Well, we'll file the complaint and then we'll engage in discovery and see what happens," that's the legal equivalent of a shrug. It shows they have no vision, no proactive plan. They're a reactive lawyer, and reactive lawyers lose. A great lawyer, a strategist, will light up when you ask this question. They've already been thinking 3 moves ahead. Their answer will be specific, logical, and confident. They'll say something like, "Okay, great question. Step 1, tomorrow morning we send a litigation hold letter to the other side. It's a legal notice demanding they preserve every single email, document, and text message related to this case. We want to lock down the evidence before they even think about deleting it. Step 2, while they're processing that, we'll immediately file a subpoena for the bank records from the third-party company involved, because that's the objective proof we need. Step 3, I'll begin drafting the complaint, but I'm going to focus specifically on the breach of fiduciary duty claim, because the law allows us to ask for punitive damages on that count, which gives us incredible leverage right from the start." That is the answer of a chess player. It's proactive, it's strategic, and it shows they're not just thinking about filing a case, they're thinking about how to win it. They have a plan. Now, for the final and perhaps most difficult question. This is the one that will test their honesty and their confidence. You need to ask, what is the biggest weakness in my case? What is the single best argument the other side is going to make against us? The reaction to this question is incredibly telling. A weak or insecure lawyer, or one who is desperate to get you to sign the check, will get defensive. They'll brush it off. They'll say, "Don't you worry about that, we have a very strong case," or, "They don't really have any good arguments, we'll be fine." This is a salesperson talking, not a lawyer. They're selling you a fantasy because they think that's what you want to hear. But a true advocate, a real expert, will respect this question. They will appreciate it. They will see you as a serious partner in this fight, not a naive client to be coddled. A great lawyer will lean in and answer honestly. They'll say, "That's the most important question you could ask. Our biggest challenge is the email you sent on May 15th. They are going to frame that email as you agreeing to the new terms. They will show it to the judge and jury and say it's a smoking gun. Our entire strategy will be built around neutralizing that one piece of evidence. We will argue it was sent under duress, that it was taken out of context, and we will find other communications that show your true intent. But we need to be prepared for it. That email is our main hurdle." An answer like that might feel scary to hear, but it should be the most reassuring thing in the world. It proves the lawyer is not blinded by optimism. It proves they have critically analyzed your case from the enemy's perspective. It proves they are a realist, a strategist who is preparing for the real battle, not just the easy one. And most importantly, it proves they respect you enough to tell you the truth. Honesty in a lawyer isn't a bonus. It's the entire foundation upon which a successful relationship is built. If they aren't honest with you about your weaknesses in the first meeting, they will never be honest with you when things get tough down the road. Ultimately, after all the tests and all the questions, you're left with one final piece of data: your gut. How did this person make you feel? Did you feel heard? Did you feel respected? Did you feel a sense of confidence and clarity? Or did you feel rushed, intimidated, or confused? The attorney-client relationship can be long and incredibly stressful. You are choosing someone to be your guide and your champion through one of the most difficult periods of your life. You have to trust them. You have to believe in them. Your intuition is a powerful tool. Don't ignore it. The best lawyer on paper might not be the best lawyer for you. The one who passes the listening test, the translation test, the strategy test, and the honesty test, and the one who your gut tells you is the right partner for this fight, that is the one you hire. So you've made your choice. You've found your champion. You're ready to sign on the dotted line. But hold on. Before you do, you're going to be handed one of the most important and most misunderstood documents in the entire legal process: the engagement letter, also known as the retainer agreement or fee agreement. This is the moment where the excitement of finding the right lawyer can turn into a cold sweat of confusion and anxiety. It's dense, it's full of legalese, and it's all about money. But this document is not your enemy. It is your single greatest tool for preventing surprises and misunderstandings down the road. It's the constitution for your relationship with your lawyer, and you need to understand every single word before you sign. Think of this as the final and most critical test. Let's break down the 3 main ways lawyers get paid, because if you don't understand this, you understand nothing. First, the one you see on all the billboards, the contingency fee. This is the famous "we don't get paid unless you get paid" model, and it's most common in personal injury cases, like car accidents or medical malpractice. The lawyer agrees to take a percentage of whatever money they recover for you, usually somewhere between 30 and 40%. Sounds simple, right? But the devil is hiding in one little word: costs. Case costs are the out-of-pocket expenses required to fight your battle. Things like court filing fees, paying for expert witnesses, the cost of a court reporter for a deposition, travel expenses. These can add up to thousands or even tens of thousands of dollars. The critical question you must find in that agreement is this: is the lawyer's percentage calculated from the gross recovery or the net recovery? Let me show you why this matters. Let's say your case settles for $100,000. And let's say the costs to get there were $10,000. If your lawyer's 33% fee is calculated on the gross amount, they take $33,000 right off the top. Then the $10,000 in costs comes out. You are left with $57,000. But if the agreement says their fee is calculated on the net recovery, it's a different story. They take the $100,000, subtract the $10,000 in costs first, which leaves $90,000. Then they take their 33% of that $90,000, which is about $30,000. You are left with $60,000. That one word, gross versus net, is a $3,000 word. You need to know which one is in your contract. Next up, the hourly rate. This is the standard model in family law, business disputes, criminal defense, and many other areas. You are paying for the lawyer's time measured in hours. Simple enough. But you need to ask, what is the billing increment? Most firms don't bill by the minute. They bill in tenths of an hour, which is a 6-minute increment. This means a 30-second phone call to ask a quick question gets billed as 6 minutes of their time. A 2-minute email gets billed as 6 minutes. A 4-minute review of a document? You guessed it. 6 minutes. It adds up incredibly fast. Your agreement should also clearly state who is billing at what rate. You might have hired the partner at $600 an hour, but an associate at $350 an hour might be doing the research, and a paralegal at $175 an hour might be handling documents. You need a full rate sheet so you're not surprised when you get a bill with work from 3 different people you didn't know were involved. Now, that hourly rate is almost always paired with something called a retainer. This is probably the most confusing term in the legal world. A retainer is a down payment. You give the lawyer, say, $5,000 to get started. That money does not go into the lawyer's pocket. It goes into a special separate bank account called a trust account. As your lawyer works on your case, they will bill their time against that $5,000. When the money in the trust account runs low, they will send you another bill and ask you to replenish the retainer. The agreement must be crystal clear that this is a refundable deposit for future work. If your case resolves quickly and there's still $2,000 left in the trust account, you get that money back. Be extremely careful if you see the phrase, non-refundable retainer. In many states, these are heavily restricted or even against ethical rules, because you always have the absolute right to fire your lawyer at any time, and you shouldn't be financially penalized for exercising that right. Finally, there's the flat fee. This is common for cases where the amount of work is predictable. Think of a simple will, an uncontested divorce, a bankruptcy filing, or a basic DUI defense. You pay one single price for the entire job. It's beautifully simple. But the question you have to ask is, what does that entire job actually include? Does that $5,000 flat fee for your DUI case cover everything up to a plea bargain? What happens if you decide you want to go to trial? A trial is a massive amount of extra work. Is that included, or is that another much larger flat fee? What about an appeal if you lose? The agreement has to spell out, with surgical precision, exactly where the flat fee service ends and where extra charges begin. Beyond the money, there are a few other clauses you must find and understand. Look for a section called Scope of Representation. This is the job description. It needs to be specific. It should say, "We will represent you in the matter of your breach of contract dispute with ABC Company regarding the invoice dated May 10th. It should not be vague. This protects you from a lawyer later saying, "Oh, handling the countersuit from them wasn't part of our original deal. That's going to be extra." Also, look for a communication clause. Does the firm promise to return your calls within 1 business day? Will you get a monthly update? Who is your primary point of contact? This sets expectations from day one and prevents that awful feeling of being left in the dark for weeks on end. And finally, look for the exit strategy, the termination clause. This outlines what happens if you fire them or if they need to withdraw from your case. How are final fees calculated? How do you get your file, which is your property, back? Hoping for the best is not a plan. You need a clear procedure for the worst-case scenario written right into the contract. And here is the ultimate red flag, the one thing that should have you grabbing your documents and sprinting for the door. Pressure. If a lawyer or their paralegal is pressuring you to sign the fee agreement right now on the spot, telling you, it's just a standard form, and you don't need to take it home to read it carefully run. A confident, ethical, and effective lawyer wants you to be a fully informed and comfortable client. They want you to understand the terms of your partnership. They will encourage you to take it home, read it, and call with questions. Someone who uses high-pressure sales tactics to lock you in is not a partner. They are a salesperson, and that is not the person you want in your corner when everything is on the line. This document isn't just a formality. It's the foundation of your entire case. Getting it right, understanding every clause, and feeling confident in the terms is not just about money. It's about establishing trust, transparency, and setting the stage for a successful partnership from the very first day. Now that the ink is dry on that agreement, you might think your job is done. You've handed over the keys to the kingdom, and now you just sit back and wait for the victory parade. But in reality, your most important work is just beginning. The most successful legal outcomes, the ones that become legendary, aren't just won by great lawyers. They are won by great lawyers paired with great clients. You are not a passive spectator in this process. You are an active, indispensable member of the legal team. In fact, you are the CEO of your own case. Your lawyer is your expert counsel, your strategist, your advocate in the courtroom. But you are the ultimate decision maker. You provide the mission and they execute the strategy. Embracing this role is the single biggest shift you can make to dramatically increase your odds of success. Your first and most critical responsibility is to become the chief archivist of your own life. Your lawyer is an expert in the law, but you are the world's foremost expert on the facts of your case. Your memory, your documents, your emails, your text messages, this is the raw material from which a winning case is built. Before you even think about your lawyer spending a single billable minute, your job is to gather and organize everything. Every contract, every invoice, every photograph, every digital breadcrumb. Create a timeline of events. Write down a list of key players and their roles. Why? Because every hour you spend doing this is an hour your lawyer or their paralegal doesn't have to, saving you potentially thousands of dollars. But more importantly, it forces you to re-engage with the facts, often revealing details you had forgotten. A crucial email, a specific date, that can completely change the complexion of your case. When you hand your lawyer a neatly organized file or a digital folder with a clear timeline, you're not just giving them information. You're giving them a head start. You're showing them you're serious, organized, and a partner they can rely on. This leads to the most sacred rule of the lawyer-client relationship: absolute, uncompromising honesty. You must tell your lawyer everything. Not just the parts that make you look good. Not just the facts that support your side of the story. You must tell them the ugly parts. The embarrassing parts. The parts you're afraid might hurt your case. Why? Because your lawyer is your legal shield. And a shield full of holes is useless. Telling your lawyer only the good parts is like telling your doctor about your headache, but failing to mention the crushing chest pain. They can't treat a disease they don't know exists. The opposing counsel's entire job is to find your weaknesses, to uncover the very facts you're tempted to hide. If your lawyer hears about that damaging email or that inconvenient witness for the first time in a deposition, or, even worse, in the middle of a trial, the damage is catastrophic. It's an ambush they can't defend against. But if you tell them up front, they can prepare. They can build a strategy around it. They can frame it. They can neutralize its power. A good lawyer is never surprised by the facts. They are only surprised by a client who hides them. Remember, the attorney-client privilege is one of the oldest and most sacred protections in the legal system. What you tell your lawyer in confidence stays in confidence. Use that protection to arm them with the single most powerful weapon in any legal fight: the truth. The whole truth. With the foundation of partnership and honesty established, the next layer is communication. This is where many lawyer-client relationships either flourish or fail. From day one, you need to establish a clear communication protocol. Ask them directly, what is the best way to communicate with you? Is it email? Is it a scheduled phone call? Who is my primary point of contact? Is it you directly, or a paralegal or associate for day-to-day matters? How often can I expect to receive updates on my case? Getting these answers up front prevents a world of anxiety and misunderstanding down the road. The legal system moves at a pace that can only be described as glacial. Weeks or even months can go by with no apparent activity. This silence is not necessarily a sign of neglect. It's often just the nature of the beast, waiting for a court date, waiting for opposing counsel to respond, waiting for the discovery process to unfold. An agreed-upon update schedule, say a bi-weekly email summary, can provide peace of mind without you having to constantly call and ask, "What's going on?" When you do need to communicate, be a professional. Your lawyer is juggling dozens of cases. A rambling stream of consciousness email that's 5 pages long is likely to get put at the bottom of the pile. Learn to communicate with precision. Use a clear, concise subject line, like "question regarding Johnson deposition date." Use bullet points to list your questions or concerns. Stick to the facts. If you provide a well-organized, easy-to-digest email, you're far more likely to get a quick and effective response. You're making it easy for them to help you. And remember, every email they read, every phone call they take is likely being billed. Being efficient in your communication isn't just respectful of their time. It's smart for your wallet. But what happens when the communication breaks down? What happens when the partnership starts to feel one-sided? You also need to be vigilant for red flags that suggest your trusted advisor might not be the right fit after all. The first and most common red flag is the ghost. You email, and you get nothing back for weeks on end. While you shouldn't expect daily updates, a complete lack of response to reasonable inquiries is unacceptable. Your case is one of the most important things in your life, and you deserve the courtesy of a timely reply, even if it's just an acknowledgement from a paralegal that your message was received, and the lawyer will get back to you next week. Another serious red flag is the surprise. This usually comes in the form of a bill. You open your monthly invoice and see charges that make no sense, for work you never authorized, or for hours that seem wildly inflated. A good lawyer will be transparent about billing from the start, and will communicate with you before undertaking any major, costly action. Unexpected. Massive bills are a sign of poor communication at best, and unethical billing practices at worst. Similarly, be wary of the unprepared performer. This is the lawyer who shows up to a meeting or a court hearing and seems to be learning the facts of your case for the first time. They fumble for documents, confuse names and dates, and seem unsure of the core strategy. This signals that they are not giving your case the attention it deserves, and that is a direct path to a disastrous outcome. Finally, watch out for the pressure cooker. This is the lawyer who suddenly and aggressively pushes you to accept a settlement offer that you feel is unfair or inadequate. While it's a lawyer's duty to advise you on settlement offers, their role is to advise, not to command. They should be able to clearly articulate the pros and cons, the risks of going to trial, and why they believe this offer is or is not in your best interest. If you feel like you're being bullied into a decision without a clear logical explanation, it may be because they are looking for a quick payday and an easy exit, rather than fighting for your best possible result. If you see these red flags, your first step should be to schedule a frank, direct conversation with your lawyer. Express your concerns calmly and clearly. Document the conversation in a follow-up email. If things don't improve, you always have the right to seek a second opinion or even change lawyers. Firing your lawyer is a major decision, but staying in a failing partnership is far worse. Ultimately, navigating the legal world is about building a powerful strategic alliance. You are not just hiring a service provider. You are choosing a partner for one of the most significant battles of your life. Your knowledge of the facts, your organizational skills, your honesty, and your clear communication are the fuel. Your lawyer's legal expertise, strategic thinking, and advocacy skills are the engine. When you combine them, you create a force that is far greater than the sum of its parts. You transform from a nervous client into a formidable opponent. When you master this partnership, you're not just hiring a lawyer, you're building a war machine. But even with the best lawyer and the perfect partnership, the legal battlefield has its own rules and rhythms. In our final part, we'll pull back the curtain on the litigation process itself, the strategies, the mind games, and the realities of what it truly takes to win. The entire process is a strategic campaign, fought not with armies but with arguments, not on a field but in a conference room and a courtroom. And it begins with a phase that sounds deceptively simple: discovery. This isn't just about finding things out. It's about intelligence gathering on an industrial scale. It's the legal equivalent of sending spies deep into enemy territory to map their defenses, learn their secrets, and find their weaknesses before the first shot is ever fired. Your lawyer will deploy a series of powerful tools. First, there are interrogatories. These aren't casual questions. They are written, sworn inquiries sent to the other side, designed to pin them down on the facts. A great lawyer crafts these questions like a surgeon uses a scalpel, with precision, aiming to extract specific, critical information that can be used later to dismantle the opposition's case. Then comes the request for production of documents. This is the demand to see everything: emails, contracts, text messages, internal memos, financial records. It's your lawyer saying, "Show me your hand. Show me all of it." Sifting through these mountains of paper and data is a monumental task, but it's where cases are often won or lost. A single overlooked email or a doctored invoice can become the linchpin of your entire strategy. But the real heart of discovery, the moment of high drama, is the deposition. This is where the other party, and their key witnesses, must sit across a table from your lawyer and answer questions, under oath, with a court reporter transcribing every single word. This is not a friendly chat. It is a calculated, high-stakes interrogation. A skilled lawyer in a deposition is a master of control. They control the pace, the questions, the flow of information. They will ask the same question 5 different ways, from 5 different angles, not because they didn't hear the answer, but because they are testing for inconsistencies, searching for the crack in the witness's story. They will feign confusion, show empathy, or apply relentless pressure, all to see how the witness reacts. They are not just gathering facts, they are assessing the person. Are they credible? Are they likable? Will a jury believe them? A deposition can shatter a witness's confidence, expose a lie, or force a key admission that completely changes the landscape of the case, often leading to a settlement before a trial is ever necessary. With the intelligence gathered, the next phase begins: motions practice. This is the legal chess match that happens long before the jury is ever assembled. It's where your lawyer tries to shape the battlefield in your favor, or even win the war outright. They might file a motion to dismiss, arguing that, even if everything the other side says is true, they still have no legal case. It's an attempt to end the fight before it truly begins. More common is the motion for summary judgment. This is one of the most powerful moves in a lawyer's arsenal. In essence, your lawyer goes to the judge and says, "Your Honor, based on all the evidence we've gathered in discovery, the undisputed facts are so overwhelmingly in our favor that there is no need for a trial. We should win right here, right now." Winning a motion for summary judgment is a knockout blow. It saves you the immense cost, stress, and uncertainty of a trial. This is where a lawyer's sharp legal mind and persuasive writing skills are paramount. They must take a mountain of complex facts and distill them into a clear, compelling argument that convinces a judge that no reasonable jury could possibly find for the other side. If these pretrial maneuvers don't end the case, you head to the main event, the trial. This is the theater of law, and every element is a performance. It starts with jury selection, or voir dire. This isn't about picking jurors, it's about deselecting them. Your lawyer is a psychologist, reading body language, analyzing answers to subtle questions, trying to identify and remove people whose life experiences or hidden biases might make them hostile to your case. They are trying to assemble an audience that is, at the very least, open to hearing your story. Then come the opening statements. This is your lawyer, the storyteller, standing before the jury and laying out the roadmap of the case. They aren't arguing yet. They are making a promise. They are saying, "This is what the evidence will show. This is the story you are about to hear. And by the end, you will have no choice but to find in our favor." A powerful opening statement frames the entire trial, giving the jury a lens through which to view every piece of evidence and every witness testimony that follows. The core of the trial is the presentation of evidence and the examination of witnesses. When your lawyer questions your own witnesses, direct examination, their job is to be a guide, helping the witness tell their story clearly and persuasively. They build the narrative brick by brick in front of the jury. But the moment everyone waits for is cross-examination. This is the duel. When the other side's witness is on the stand, your lawyer's job is to dismantle their story. It's rarely the "you can't handle the truth" moment you see in movies. It's often quieter, more methodical, and far more devastating. A master of cross-examination uses leading questions, questions that suggest the answer, to control the witness. They will use the witness's own deposition testimony against them, pointing out contradictions. On May 15th, you swore under oath that you saw a blue car. Today, you're telling this jury you saw a green car. Which is it? Were you lying then? Or are you lying now? They will break down a complex story into tiny, verifiable pieces, showing the jury that the foundation is rotten. The goal is not always to get a dramatic confession, but to destroy the witness's credibility, to make the jury doubt everything they have said. Finally, after all the evidence is presented, come the closing arguments. This is your lawyer's final address to the jury. It's the culmination of everything. They are no longer just a guide. They are an advocate, a persuader. They will take all the disparate threads of testimony, documents, and evidence and weave them into a single, powerful, and coherent narrative. They will connect the dots, highlight the opposition's weaknesses, remind the jury of the promises made in the opening statement, and explain why the law and the facts compel a verdict in your favor. It is a performance of logic and emotion, an appeal to the jury's reason and their sense of justice. It is the final push, the last chance to secure victory. But here is the final crucial truth. Winning isn't always a dramatic verdict read in a courtroom. Sometimes, winning is a settlement offer on the courthouse steps that gives you 90% of what you wanted without the risk of a jury trial. Sometimes, in a criminal case, winning is a plea bargain to a lesser charge that keeps you out of jail. Sometimes, winning is simply having a lawyer who is so prepared, so formidable, that the other side decides they don't want to fight at all. And even after a verdict, the fight may not be over. There are appeals, a whole other legal battlefield with its own complex rules. Throughout this entire journey, from our first discussion about what best even means, to understanding fees, building that critical bond of trust, and now seeing the intricate machinery of the legal process itself, one theme has remained constant. The best lawyer isn't a magician with a magic wand. They are not a television character with a flawless record. The best lawyer is a partner. They are a strategist who sees the whole board. They are a communicator who translates a foreign language for you. They are a warrior who fights for you when you cannot fight for yourself. Finding the best lawyer was never about finding a perfect person. It was about finding the right person for you, for your specific problem, in your specific circumstances. It's about finding someone who understands your definition of a win and has the skill, the integrity, and the sheer tenacity to help you achieve it. The law is a vast and intimidating ocean, but with the right navigator, you don't have to drown. You can find your way to shore. And now you have the map to find them.